Good morning. There has been a slight lag delay from our end, but we will just start quickly. In today's session, we'll be looking at what was meant to be how intellectual property rights operate in creative and entertainment industries. Apart from that, we will also look at intellectual property rights, the policy the Indian government has on it, and how teaching intellectual property rights could be significant, especially in the light of the government policy to promote intellectual property rights. So, what we plan to do this week is in this session is to cover how intellectual property operates in creative industries and also to look at IPR, the national policy on IPR, and teaching intellectual property rights as a subject in various institutes. And over the next week, we would like to keep it open for some general discussions and also look at case laws. Case laws are important because intellectual property right is predominantly a legal subject. And whenever a case is decided by the court, that crystallizes or it describes the law. To understand the law, it is important even for non-lawyers to be familiar with case laws. So over the next week, we'll be looking at some landmark cases affecting intellectual property rights. Like most of you might have heard about the Novartis case, which was decided recently by the Supreme Court. And there are other interesting cases as well. So we would look at case laws as a tool of learning, and we would also give you an heads up on how to look at case laws, because as non-lawyers, some of you may find it difficult to go through case laws. So we will look at that, and we will also summarize the key findings, and we will also prepare you for how you should be looking at case laws in the future. So they are legal documents written by judges, and there are quite a lot of pleadings that go into preparation of these case laws. But there are ways in which you can quickly traverse through a case law and understand its gist. So coming back to our subject matter today, so we are here to look at intellectual property in creative and entertainment industries. Now, creative industries are sectors that focus substantially on creating and exploiting intellectual property right products. Now, this could be with regard to movie making, it could be regard to music, it could be regard to books. And books is a big category in itself, because almost all the books that we purchase would come under the ambit of a creative industry. We are not only talking about works of fiction, but also works of non-fiction, and importantly, even books that cover education, say textbooks, would also come under this category. So creation of textbooks is an inherently creative process, and especially in the light of what we saw at the DU photocopy case in the session on copyright, the question still remains there: how do you protect textbooks in this country? Because protection of textbook may not directly come out of the finding in that case. And how will textbook manufacturers invest in creation of these textbooks in such a way that their investment can be recouped? Now, going by the DU photocopy case, the court actually allows for copying of portions of textbook if it is for educational purposes. And soon after the case, there was some reshuffling, so to say, in the publishing industry, with some publishers actually pulling out or telling that they would soon be pulling out because it would not be feasible for them to get into or remain in this field. Because the moment you create a textbook and publish it, if the law allows people to make copies for educational purposes, because for a textbook, the educational institutions and the students are the primary market. So once you say that the primary market would have an exception to use it and to make copies, then the question that would arise is, how do you incentivize creation in this field? There are some models that have been proposed as to how you can make textbooks free and still make quite a lot of money in the process. But anyway, that will be beyond the scope of our discussion. But just to bring to your notice that when we talk about books, we are also looking at both non-fiction and fiction works, and more importantly, we also should be looking at how the creation of textbooks can also be protected in such a way that it can be incentivized. Now, the public sector may be interested in creating textbooks, say like the NCERT may produce some textbook, and they may even offer it on a open license. Now, that's something which we are not worried about, because there the the textbook itself is funded by the government, the creation and the dissemination part of it. Most of the or all the lectures on NPTEL is again funded by the government. So creation of intellectual property, when it is through publicly funded sources, then the further dissemination can also be controlled by the person who is in charge of creating them. But the more important point with regard to creation of textbook is, in the light of the DU photocopy case, Delhi University photocopy case, is how do you incentivize the private sector to come up with new business models such that we get new textbooks created rather than relying on textbooks that are created in other places and copying them or using copies of them. The law also need to focus on how new textbooks in our country can be incentivized within the private sector. So, creative industries, coming back to the point, covers music, books, films, games, but also sectors that focus on providing business to business creative services. Now, why do we need to protect these industries? Now, there is enough material to show that they make substantial contribution towards economic growth, and they are important for a knowledge-based economy. And especially in a country like ours, where the biggest strength is human capital, then the focus has to be on knowledge-based industries. Now, there are different ways in which you can protect creative industries, and there could be also different types of rights. And we had seen that copyright becomes the key form of right by which you could protect rights of the creative industry. Now, copyright is actually a right at one extreme of the spectrum. At the other extreme, you could say that you have works in the public domain, which means anybody can use those works without getting the consent or the permission of the creator. In between what is available in the public domain, and that's at one extreme, and the other extreme of copyright, you have various different kinds of arrangements, licensing arrangements like the Creative Commons, which would help both in monetizing the creative works as well as in allowing for a wider and a better dissemination. So if we look at creative industries at some point also overlap with cultural industries. So you can see the core copyright industries like press, literature, music, theater, operas can be protected by copyright. And you can also see software, database, and computer games, which could partially be protected by copyright, because some of the softwares are best protected by business model, innovative business models, rather than just by protecting the code. Almost all the apps that you know today, which you are using, say, let it be Uber or any of the other apps, they are protected by strong business models than by protecting the code itself. So, and you also have design protection for these works, and the subject matter could be something that is created by the private sector, and it could also be something that is created by communities. So, the creation would lead to production and manufacturing, then that could lead to dissemination and distribution, and finally to consumption. So protection could extend to all these parts, and you will see the issue with creative industries is that at the point of consumption, there seems to be issues with regard to protection itself. And piracy, which you will see soon, is one of the issues that happens at the point of dissemination and consumption. Now, the global value of these industries have been, there are different accounts. They say that between 4 to 6.5% of the contribution to GDP is largely because of creative industries. And sometimes creative industries go beyond just books and films and music. It could also be design elements that you sometimes find in products. Say a shoe apparel company like Nike is predominantly a design company, and they are uh, the way they monetize their work is by designing cutting edge products which are produced in different parts of the world. Similarly, Apple could also be seen as a design and a marketing company. So this leads to rapid economic growth, and sometimes the economic growth could be attributed to the creative industries themselves, and it also creates employment, and employment in, as I said, in economies which are more centered on human capital. It could be a way for uh, massive growth. Now, in India, media and entertainment are one of the fastest growing sectors, and we have the largest film producing market. And India is also the third biggest internet market with more than 500 million internet users. Now, the rights of creative industries would pertain to protection and exploitation of the right. Now, managing IP would involve what rights you own in your original work, identifying yourself as the creator and the right holder, then exploitation of the IP by licensing an agreement and by enforcement. Now, if you look at this, actually covers the creation till dissemination and exploitation of the work. Now, the rights can get affected at each one of these stages. They could be disputes with regard to the work itself as to who is the owner of the work. There could be issues with regard to exploitation when it is licensed, and also issues when it comes to enforcement. Now, the creative sectors include advertising, film and television, sports, music, publishing, where we can cover both academic and non-academic works, and fiction and non-fiction, and also video games. Usually, we have a copyright notice, and if you had seen YouTube videos, you can see copyright notice at the end for theatrical, musical, and artistic works. This is to show that the work is protected, and also that to show that the author owns the copyright. And the copyright, as we have already covered, the term of the copyright is life of the author plus 60 years. And copyright regime also allows for royalty payment for licensing the works. Now, copyright, some of the scholars have said the copyright regime itself would be irrelevant when it comes to the internet. Now, there are reasons why they say this. Normally, if you need to copy somebody else's work, one way to do that is to quote portions of it and give a reference to it, attribute the source. And again, in traditional copyright, there are limits as to what you can show. For instance, you cannot quote an entire chapter of a book in your work, whereas you can only quote parts of it, and you may have to paraphrase it and give the proper reference. Now, internet brings in another dimension to this. Now, on the internet, there is no need for you to even produce or reproduce any other person's work. You can simply give a hyperlink to the work, and the entire work will be available for the person who is viewing it. So rather than giving a footnote, you could also give a hyperlink. And if the source that is hyperlinked is available as an open source, in the sense that it is freely available for a person who accesses it, then that would mean that the copyright regime in itself, which ordinarily protects people from making copies of a work, would be irrelevant, because the source can be hyperlinked and be made available to the viewer. So, copyright has certain issues. Some scholars have said that it's time that the copyright laws are amended, especially when it comes to the internet. And there are also been new models of protection that have been advocated. And one of the things is with regard to digital rights management. Copies of digital works which can easily be copied on the internet. And we had a case pertaining to peer-to-peer sharing, which is called the Napster case. Napster used to be a software tool that was used for peer-to-peer sharing of largely musical works. And at one point, there were 60 million Napster users. And that was largely illegal in the sense that the sharing happened without paying any royalty to the creator. But then law came around and they created digital management rights by various statutes and enactments, which largely did three things. One, there was a code in the file which made it difficult for people to copy. Two, it brought a restriction on the use itself. The time period within which you could use was restricted, and the number of devices on which you could use the copy of the file was also restricted. So, digital management rights evolved as a way to protect copying or peer to peer sharing on the internet, and that was seen as a need. Now, soon after the Napster, which was a website which allowed for a software which allowed for peer to peer sharing, soon after it was declared illegal, you had certain other forms coming up, business models coming up, which allowed for easy purchase of a audio file. For instance, the MP3 players were in vogue since the 1990s. There were different manufacturers who were manufacturing MP3 players, and MP3 players were one of the means by which you could easily copy and share files. But when Apple came up with its iPod, Apple also tied the gadget, which is iPod, and Apple was not the first person or the first company to come up with an MP3 player. They smartly tied it with their iTunes software, which allowed a person to buy a single track at an affordable price. Now, this was a remarkable change in the way in which the music business worked, because earlier the only way you could buy a musical work was by buying the entire album. So whether you wanted the entire thing or not, you had to buy the entire album. Now, Apple revolutionized the business process by allowing people to buy individual tracks, and they priced it at less than $1 as well. So Apple not only brought this entire range of musical works through a forum by which you could legally purchase it, it also combined it with a nicely designed gadget for consumption. So there was a business model which was largely iTunes allowing you to buy individual tracks at an affordable price, coupled with a sleek designed and nicely designed gadget. So this led to opening up a new market which was earlier not there. And before that, we had Napster, wherein we had 60 million users sharing files without paying any royalty. So we see a shift in the market. We also see a shift in the way in which law perceived digital rights management. They said that peer-to-peer copying will be allowed only in limited purposes. Say you had two gadgets, you want to make copies of it and retain that, or you could have backup copies, but it would not allow you to share it with others without paying the royalty. So this new model ensured that there was some kind of protection for digital works. Now, while this was happening, creative industries were also interested in protecting the term of copyright. So the term of copyright is largely fixed, but in some countries, especially in the United States, we see a tendency for the creative industries, especially Disney, to lobby with the government in such a way that they could extend the term of the copyright itself. Now, there is enough material to say that this was largely done to keep Mickey Mouse from falling into the public domain. And in the US, initially, the copyright term used to be for 14 years. But then over a period of time, it became similar to what was in India, life of the author plus 50 or 60 years. Now it has reached a point where the copyright would extend up to 120 years from the date of creation. Now you can see this chart, and you'll see that the Sony Bono Act actually extended the right of creative works up to 120 years, and this is attributed to Disney's lobbying to protect Mickey Mouse, the copyright over Mickey Mouse. Now, creative works also could have an impact on how they are marketed. Now, marketing is a significant way in which creative industries can recoup their investment and also allow users to keep purchasing their goods. And intellectual property is instrumental in building the company's brand. Now, we have been seeing the role that copyright can play in the creative industries, but trademarks also play a significant role. In fact, any of the products that Apple comes out with, it's largely because of the brand value of the company and the fact that users attribute value to their product. There is some kind of a hype around the products. In fact, the same can be said for certain kinds of works of fiction, like say the Harry Potter series. And for one thing that's common for both Apple products and Harry Potter books is that people queue up before the product is released in long lines so that they could claim to be the first purchasers. So this is nothing to do, though they are all creative works. This has nothing to do with the copyright protection in itself. This is largely because of what the brands have grown to be. So the brand, both Harry Potter and Apple's products, they have grown to be attributed with a particular type of quality. And because the brands are protected all over the world, you can now see that they could be marketed in a smart way, in such a way that people have a following for it. Now, marketing could also result in others capitalizing on your marketing moves. Now, there is something called ambush marketing, where an advertiser ambushes an event to compete for exposure against competing advertisers. Now, every time there is a grand or a mega sale by one person, you could find others stepping in and capitalizing on that. Now, one of the best instances of ambush marketing in India happened a few years ago when the Cricket World Cup was conducted in India. For the event, Coca-Cola was successful in getting the official sponsorship. So Coca-Cola literally became the official drink of the Cricket World Cup. Pepsi lost out on the contract, but Pepsi came up with a smart campaign called Nothing Official About It. And they ran a campaign with different cricket players in such a way that they were largely seen as having a bigger impact than the official sponsor itself. So they ran a series of ad which with the campaign that Nothing Official About It, and that got quite a lot of traction for Pepsi. Now, soon after this, there were regulations that came in saying that the team players that are themselves bound by advertising only for the sponsors of the event, and they cannot do it for others who are not sponsors of the event. And we also found the logos, the name of the event itself being a proprietary thing. There were restrictions on their use. So even if a newspaper was covering an event, the newspaper uh, had to get a license from the event organizer to use the name. Say it was the ICC World Cup or the FIFA World Cup. So they were all branded and protected words. So you could not do any kind of ambush marketing, and the event organizers themselves were willing to give this on a license. So here you have the ambush marketing between where Snapdeal uses Flipkart's greatest sale ever. And you can see that when Flipkart advertises for a sale, Snapdeal comes up by saying that for others it's a big day, for us it's not different. Just making use of the fact that there is a sale happening with a competitor by coming up with something as a parallel event. Now, creative industries also have issues with regard to licensing. Now, it you could sell the authority for a third party to use the owner's right, and you could also stipulate certain conditions on the sale. Now, in IP licensing, recently we had the case where the tennis player Roger Federer disputed with Nike. Nike was the sponsor for Federer for a long time, and Nike also developed the RF logo along with Roger Federer. The dispute arose because Federer moved to a new sponsor this year for Wimbledon. He moved with a new sponsor, and he also made a statement that he should be entitled to use the logo RF. RF is actually a abbreviation of Federer's name, but RF logo was protected by trademark, and the trademark was owned by Nike itself. So sometimes when owners of the trademark may give up their right without knowing the consequences of it. So there is still a dispute pending, and Federer has made it clear that he would like to use the abbreviation of his name, but the law is in Nike's favor because Nike owns the abbreviation. Now, merchandising, as you had seen, especially in the case of Disney's works, is a way in which creative industries can protect their creative works. Now, merchandising would involve protection by way of trademarks and copyright, and that's one of the reasons why Disney had lobbied to extend the term of the copyright for Mickey Mouse, because it becomes more effective to protect these creative works by way of copyright and trademark. Now, creative industries are also protected by broadcasting rights. Broadcasting rights are also referred to as neighboring rights because they are rights that are that ancillary to copyright. So, the rights a broadcasting organization negotiates with a commercial concern. So, with regard to mostly this could be with regard to a sporting event where it could be a sporting body, or it could be with regard to a motion picture where it have to negotiate with the film distributor. Now, sports is itself is a billion-dollar industry, and we find that there have been issues with regard to what amount of sporting event can be, the information of sporting event can be disseminated. There were issues in our country with regard to whether live scores can be shared, and the event organizers claim that no live scores are uh, uh, proprietary material that is generated in the sport, and hence it should not be shared. Whereas news channels said that live scores of a live event amounts to hot news, and they said that that is something that should be covered by the freedom of press to disseminate news. So again, the key point to note here is that there is quite a lot of value that comes out of these industries, and there is a constant struggle to see how that value can be capitalized. Signal theft is another issue, and you would constantly see cable channels relaying certain numbers, and which is a way in which they can detect signal theft. Now we will move to the next presentation. Now what we had seen is we had seen how the different types of rights that work with regard to creative industries. We had seen copyright, trademark, rights with regard to merchandising and broadcasting. Now let's look at piracy in the film industry, because this is something which is one of the reasons why we had seen certain changes in the law. Any unauthorized use or reproduction of another's work is can be termed as a pirated work, or the act can be referred to as piracy. And this is one of the biggest threat to the film industry. And you would see that the lifespan or the shelf life of creative works coming down largely because of piracy. Now, earlier we had instances of uh, uh, theatrical works, movies running for 100 days, 200 days, or even more. Now, the lifespan has become so short that in the first release and the follow up sale for broadcasters like cable television, the right is almost captured at that level itself. I mean, it is monetized. So the first few days become very important because of issues with regard to piracy. And there are three major forms of piracy in India. One is in the home video market. There could also be piracy, cable piracy, and unauthorized communication of movies in public places. Now, copyright piracy could result by exposure to different pirate media, like streaming of pirated movies online. And there are various software tools available for downloading movies, downloading pirated movies, and also possessing or sharing pirated movies by VCDs or DVDs. Now, the social cost of piracy is that it negatively affects the livelihood of persons involved in working the industry. Again, that's the incentive argument. If piracy is not curbed, then the creators will not be sufficiently incentivized to invest in creation of new works, and it could also be detrimental to the economy itself. Now, there are some social benefits in piracy in the sense that the artistic works get better coverage, and it would make the artist more popular. In fact, one of the models that has evolved in the West as a response to piracy of soundtracks was that the creators, the artists, concentrated on live events, because live events, by ticket sales you could monetize your live events, and they themselves release the audio tracks for free to their fans. So this was a innovation by which they could not only curb the piracy because they were themselves instrumental in releasing the track for free, but they monetized their works by live shows, and they increased the number of live shows they would do in any given year. So there is a social benefit to piracy in that it makes the creator more popular, and the legal risks are copyright infringement, and since copyright infringement is a criminal offense, there could also be imprisonment apart from fine. Now, that was a very short description on piracy. Now, we would now move on to cover the two things that were left out on we had actually scheduled to cover this in the next week, but we want to cover the government's role in fostering IP and teaching intellectual property this week, so that we have some time to cover the case laws and have some Q&A sessions next week, which is the last week of our course. Now, let's look at the government's role in fostering IP. Now, the Department of Industrial Policy and Promotion, which comes under the Ministry of Commerce and Industry, now has the complete mandate to regulate all the intellectual property rights in the country. Earlier, we had a fragmented setup where certain intellectual property rights were outside the purview of the Ministry of Commerce and Industry. For instance, copyright was handled by the Ministry of Human Resource Development. Now, copyright has come under the DIPP's purview, and DIPP is now the central body that looks at formulating IP policies, and also ensuring that IP is governed and enforced in the right way. So the DIPP has been in charge of coming up with the national IPR policy. There is also a body called CPAM, uh, Center for Intellectual Property Advocacy and Management, which is a body under the DIPP, which does quite a lot of work in disseminating and advocacy works in uh, intellectual property rights. And there is also this scheme, SPRIHA, Scheme for Pedagogy and Research in IPRs, uh, for holistic education and academia. So this is the scheme by which the intellectual property right chairs were established, and that is a scheme that has been a continuing scheme. And so you have a national IPR policy, you have a body that is mandated uh, to conduct workshops and seminars and to spread or to educate people on IPRs. And you also have this scheme for research and education on IPRs, which is largely what constituted the IPR chairs. So the national IPR policy lays the future roadmap for IPRs in the country. It's a visionary document which aims to create and exploit synergies between all forms of IP. And the mission is to stimulate a dynamic, vibrant, and a balanced intellectual property rights system in India. Now, it's easy for you if you just do a simple web search, you will find this document. And the objectives are first, at the first level, to create IPR awareness, and that is one of the biggest tasks in a country of our size. And once we create awareness, we will be able to let people identify their IPRs, and only if IPRs are identified can they be protected and monetized. So the logic is to first concentrate on awareness, then on capacity building, and once the capacity is built, you could have IPs that are generated to be protected by the various frameworks that we have. So the second focus is on generation of the IP itself, and this could largely be in knowledge centric or in knowledge intensive industries as well as in academic institutions. And the policy also talks about the legal and legislative framework. India has various IP laws. Some of them have been effective, some of them have not taken off. As we mentioned, the law with regard to protection of layout of semiconductor chips, we have only seen 2 registrations so far. Then the policy also talks about administration and management of IPR and commercialization of IPR, enforcement and adjudication, and human capital development. Now, when the IPR policy came, as with most policies, there were some criticisms as well, and there were issues with regard to saying that the IPR does not focus on innovation. Rather, the country needs an innovation policy and not an IPR policy. But another way to look at it is to see that IPRs are a short form for innovation. It's a quick way by which you can educate people, build awareness and capacity by just telling that once there is some innovation and a creative works come out of that innovation, it can be protected by IPR. So we can also look at IPR as a short form or a quick way to tell people about innovation, because since IPR sit at the top of innovation, because products of innovation could be protected by IPR, it also could be a quick way to educate people about innovation and the products that result from innovation. CPAM stands for the Cell for IPR Awareness and Management. Sorry, I mentioned it as advocacy. It's awareness and management, and this is created under the DIPP. And there is a scheme for IPR awareness. Creative India and Innovative India are some of the themes that have been created for spreading IPR awareness. And the role of CPAM is to conduct workshops, seminars, training programs with the industry, academia, and other stakeholders. And the scheme, SPRAHA, by which the uh, IPR chairs were established, earlier they were done under the MHRD. Now the chairs have been moved to the DIPP. And the object was to set up IPR chairs in higher educational institutions to encourage the study of education in and research on IP, to promote outreach of IP matters, and to develop credit specialized courses on IP. Now, this was the role that was envisaged for the IPR chairs. We also find that sometimes it becomes difficult to teach IPR in certain institutions because there is no ground level capacity. In fact, when we were involved in formulating the guidelines for AICTE, the institutions under the AICTE, we had advised the institutions to not to make IPR courses mandatory because of the lack of sufficiently trained staff to teach IPR in most of the institutions. So now we'll look at the challenges in teaching IPR soon after this. And there are also other measures that have been done which are incidental to IPR, like the expenditure on science and technology, that is the research budget. Uh, we have numbers saying that 0.7% of the GDP is spent on R&D, and we also have the CSIR, which looks at, there are various labs under the CSIR which looks at IP generation and protection as well. So publicly funded research is protected by various types of IPR, largely by filing patents in India and abroad. And CSIR is also one of the largest filers of patents in India. Enforcement of IP also becomes an issue, and 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 we, and the IPR policy also talks about the various international treaties that India has already signed or will be signing soon. So that's another mandate of the IPR policy, to look at the international treaties that are coming up and to see what should be India's position on those treaties. Teaching intellectual property has certain difficulties, especially when intellectual property has to be taught to non-lawyers. Traditionally, intellectual property rights are subjects that are taught in law schools. And again, it is not a subject that is taught in the initial years of study. So it's something, it is a course that will come in the final years of study, in the fourth or in the fifth year. This is largely because of the principles of IP cuts across different subjects. For instance, a law student will know that there are elements of tort law in IP, there are elements of criminal law in IP, there are elements of contract law in IP, constitutional law, international law. So IP, intellectual property rights, a legal student or a law student will know that it is actually a conglomeration of different legal subjects. So that's one of the reasons intellectual property rights is not taught in the first year or in the second year of an LLB course. Now, how does this relate to other branches of law? We are already seen that certain types of intellectual property rights, like copyright and trademark, can have criminal sanctions. Infringement is made a criminal offense. So that brings in aspects of criminal law. Criminal law is a separate subject in itself. Intellectual property can be licensed, and it is normally licensed through agreements, and agreements are governed by principles of contract law. Intellectual property rights are created under the Constitution. They are subject matters which come under the union list. The central government has power to create it. And some intellectual property rights may affect the right of freedom of speech or some of the fundamental rights. So in that sense, there is a bearing on constitutional law as well. Intellectual property right, when there is an infringement is treated as a tort. The remedy of an infringement can be by way of compensation or by way of injunction. So the compensation part is governed by a branch of law called tort. Any civil wrong that is committed can be redressed by compensation. So that brings in elements of tort law. And finally, international law is relevant because almost all the changes that India brought into its IP regime was done by way of the international agreements to which India has been a party. So we have this top down model that international treaties would set a particular standard which all the members of those international treaties will have to comply with. India is a member, founding member of the World Trade Organization, and because of certain special requirements in the law, India had used a transition period of 10 years to bring its law in compliance with the WTO standards. So today, the Indian Patents Act had undergone three amendments in those 10 years to make it in compliance with the WTO obligation. So again, you will find that IP law also is inherently connected with international law. So, how does institution? I just brought this out to show you that teaching intellectual property rights as a subject in a law school, which has the competence to do it, itself can be a matter which can put a significant load on on the institution and the person who's teaching it. Now, how can we take IP, or how can we ensure that intellectual property can be taught in different institutions which don't even have, say, legal staff or law professors in the faculty? Now, how do we take this forward? So we will look at how IP can be simplified, and that's one way to look at it. There is no need to teach IP with the rigor that is with which it is taught in the law schools. IP can be, intellectual property can be customized, and it can also be simplified to different stakeholders based on their requirements. Now, IP education in the past was largely done by specialist lawyers because before 1990s, intellectual property rights was not even a subject, even in the law schools. In fact, the Bar Council introduced in the late 1990s, it introduced intellectual property right as a subject. So it was not even a subject before that. And that's largely because the creation of the World Intellectual Property Organization happened in the 1960s. So everything that we see with regard to the push of IP into the educational system has happened after the 1970s. Now, there is a need for IP education, and IP education preferably should be something like continuing legal education because of the nature of IP and the constant changes that happen in the field. It should ideally be something that should be a part of continuous legal education. And the challenges in teaching IP, as I just mentioned, is with regard to the skills and expertise that are available at the ground level, and also with regard to what we should be teaching. An educational institution should be designed to account for the diversified needs in an interdisciplinary manner, by which we mean the focus in institutions, technical institutions like engineering institutions, should be on patents. Similarly, for pharmacy colleges where B Pharm and M Pharm are taught, again the focus could be on patents. For for colleges on journalism and media, the focus could be on copyrights. For business schools who have a core course on marketing, the focus could be on trademarks. And for fashion and creative design industries, the focus could be on industrial designs. Now, this is just to say that intellectual property and for agricultural institutions, the focus could be on Plant Varieties Act. Now, the reason I'm just giving this is that IP comes with different complexities, and it may not be entirely necessary for us to cover the entire ambit of IP when we want to teach IP in a non-lawyer setup or in an institution where IP is taught to non-lawyers. Hence, the focus could be based on what is being taught because engineers largely deal with technology, and IP in technology can only be protected by patents. There could be a small amount of matters which could fall within the realm of copyright, but if you look at almost all the institutions, the technical institutions in our country, and now that intellectual property has become a part of the ranking system, it is also the National Accreditation Council is also looking at the innovation ecosystem of these institutions. You will find that the focus has always been on patents for engineering institutions. So we need to take an approach rather than covering the entire, though this course covers everything, it is meant for a wider audience. When we need to look at teaching IP in non-legal institutions, then we have to adopt an approach of simplifying the IP, one, and two, looking at the IP that is most relevant and to focus a course based on that. So, in apart from the law schools, it is the business schools that cover IP in some detail. Now, IP, intellectual property assets, are intangible assets, and intangible assets needs to be managed. And as you had seen, how the management scholars look at IP, they look at IP as limited life IP and unlimited life IP, and they constantly try to migrate the value in a limited life IP into a unlimited life IP. So you find, apart from the legal scholarship of IP, the management scholarship also plays a role in making contributions to the subject. So these are the two broad approaches that we have. You can take a legal approach in teaching IP, or you can take a business school approach on managing IP. But the scholarship is largely focused on the legal aspect because it has intellectual property has evolved as a legal subject. Now, as I mentioned, taking IP to non-lawyers could be a challenge, but it is important because non-lawyers, people who don't have a background in law, are actually the creators and the users of intellectual property. So, because intellectual property rights are created and used by people who belong to different segments of the knowledge industry, it is important for us to take this to non-lawyers as well. And as I mentioned, the IP education has to be customized and it has to be simplified. You have to start with the IP that is more relevant for them, and we'll have to customize it to the industries that we are targeting. If it's technology, then we'll have to focus on patents. If it is creative industry, we'll have to focus on copyright. And if it is marketing and business, we'll have to focus on trademarks. Now, future developments in IP will be interesting to watch. Machine learning and artificial intelligence has itself created certain new issues. Scholars have already started debating on whether products of artificial intelligence, which are largely mission created, should also be granted IP protection. There is nothing that is clear in the law right now because IP today is confined to products of human creative labor. And that is human creative labor at the first instance, not human creative labor leading to another product by itself. So we are not talking about second generation, third generation products. We are talking about what directly comes from human creative labor. And for this reason, law does not recognize IP even for non-humans. And we had seen the copyright selfie case where a monkey made a selfie and there was a case in the United States. Law does not extend to it because law right now defines creativity that is completely attributed to humans. So similarly, mission creativity is also not covered under this. Maybe the first mission that is created, which can make copies or which can duplicate other machines or other which can come up with other creative products could be the subject matter of IP, but all the derivative products that come out of artificial intelligence, right now the law does not have a provision for this because creative works have to be directly an outcome of human creative labor. IP will always be important when it comes to international trade. So that's another reason why we should have some amount of IP education, IP in our educational system. And certain sectors like biotechnology and computer science could also have an impact on public health. Now, there is big data that is where our health details could be anonymized and it could be used to generate very valuable resources. There are privacy issues when it comes to storing and sharing of medical data. And there are also issues with regard to protection of pharmaceutical and biotechnology products, which could have an impact on public health. So, for all these reasons, there should be some amount of education on intellectual property rights, and that has to be customized and simplified, looking at the diverse fields of knowledge in which we are currently operating. So we have some questions. So we will. Okay, we'll just look at the questions. What is the difference between a registered and an unregistered trademark? Now, a trademark is a mark or a symbol which signifies goods or services, which is connected to goods or services. So, you are selling a product, you can have a mark with it, a mark, so say the Nike mark or the Apple logo, they are all marks which will tell you the origin of the goods or services. If the owner of the mark registers the mark before the trademark office and gets a registration for it, then we say that the mark is a registered mark. Unregistered mark is a mark that has been used but not yet registered. Now, in a normal case, especially in the 21st century, you would expect all the users to register the mark. But in some cases, marks may not be registered, but nevertheless, they may have goodwill and reputation attached to it. A classic instance can be a foreign mark which does not have any operation in India, say a European company which sells shoes, and that shoe is not sold in India at all. But the reputation of the mark is such that you find over a period of time, people who travel to Europe bring the shoe, import the shoe, or bring the shoe into India and they start using it here. So the mark, though it is not registered in India, develops a goodwill within the country. So it could be the case that the entity may come into India at a later point of time and register it. But even without registration, you could protect that mark because it has got goodwill and reputation attached to it. Now, this can be done as we had discussed in our lecture on trademarks. This can be done by the remedy of passing off. So, if it is a registered trademark, then you can file a trademark infringement suit. If it is an unregistered trademark, you can protect it by the law of passing off. The difference between a registered and an unregistered trademark is the fact that there is no registration. But little does it mean that unregistered trademarks cannot be protected. As I just mentioned, there could be instances where a player in a foreign country enters India at a later date, and even if they have not entered, they could still enforce their right, provided they can show prior use in a foreign country and goodwill and reputation, transborder reputation. In that case, they may have to show transborder reputation and goodwill. And there have been cases where that has been demonstrated. What are the details that are scrutinized prior to patent publication? What are the other details that are checked during first examination? Now, before a patent application is published, the patent application has to satisfy the criteria of patentability. The criteria of patentability refers to the fact that a patent is granted for an invention. So there has to be an invention in a particular field of technology, and that technology should be protectable under the Patents Act. there are certain technologies that are not protected. For instance, atomic energy, inventions pertaining to atomic energy is not protected. So it has to be a technology that is protectable under the Patents Act. And it should have novelty, that's the first requirement. It should have inventive step, and it should be capable of commercial application or industrial application, what we also call utility. So in an application, you would describe the invention in such a way that it satisfies these criteria. For instance, you would not mention your invention in a way in which it falls within the prior art, or it overlaps with something that is already disclosed in the public domain. So that takes care of the novelty requirement. You will describe the invention in such a way that it doesn't look obvious to your peer. That takes care of the inventive step. And you would say that the possible objectives of the invention or the possible uses, which takes care of the utility requirement. Now, these are the positive requirements. There are certain negative criteria that the patent has to get over. There are exceptions to patentability under Section 3, various exceptions. You can't patent plants and animals or parts thereof. You cannot patent computers, software per se. The source code you cannot patent. There are various other exceptions. So what you would do is, while you file a patent application, you have to, prior to the filing of the patent application, you have to ensure that these details are covered in your application. Now the question says, what are the details are scrutinized prior to patent publication? I would understand that patent publication, the questioner meant prior to filing a patent application, because the application, once it is filed, it gets published just before the examination, which is a requirement in the law, so that the world is put to notice before a right is granted. Now, the same things that are looked at while filing a patent application, like the criteria of patentability, novelty, inventive step, and utility, and the exceptions to patentability, these are the things that the patent office would look into at the time of examination. So the first examination, as the questioner had mentioned, the patent office will look into whether the patentability requirements have been satisfied and whether it falls outside the scope of the exceptions. Now, the criteria of patentability, we normally refer to it as what amounts to an invention: novelty, inventive step, and utility. But there are also other requirements, internal requirements. For instance, there has to be a disclosure of the invention, and the disclosure should enable a person, it should be an enabling disclosure, in a sense that it should teach people to come up with the invention without undue experimentation or without having to get back to the inventor. So there are certain other requirements as well, but we largely go by the patentability criteria, which means the patents should satisfy the requirements under the Act. So in a first examination report, the controller would raise objections under the Act, which is largely on patentability and on exceptions to patentability. The controller may also raise small objections, like that there are certain procedural requirements. The title has to be not more than 15 words. The abstract should not be more than 150 words. So those are smaller procedural requirements, but the substantive requirements are already mentioned in the Act, and the application has to comply with it. Okay, we had last time, there was a request for a live demonstration regarding prior art search. We will be doing that next week. Next week, Monday, we will schedule a class, and we will inform you about it. And that is long due. I remember mentioning it in one of my earlier live sessions. So we will be showing you how to do a prior art search on a public database as well as on subscription database. Okay, there is a question on IP issues in nanotechnology. Now, nanotechnology is a means of achieving something. Now, that's my understanding. There is a nanotechnology is when you go beyond a particular size, you call it a nano, the microns in microns. It's a range in which a thing can be conceived. Now, because it is the science of reducing, or science of bringing down the size of things. We don't regard it, especially from a patenting perspective, we don't regard it as a separate branch. So you could employ nanotechnology in pharmaceuticals, you could employ nanotechnology in chemical, you could employ nanotechnology in biotechnology. So nanotechnology itself, from a patenting perspective, it's not a separate branch. It is rather a process which could be used in any technology. So we don't have an issue with that, because as long as the technology allows you to have it, you could, as long as it is new, it involves an inventive step and it has utility, you may get a patent. But one issue that I need to bring to your notice, where nanotechnology or using nanotechnology may still not get you a patent, or where it could be difficult to get a patent, is with regard to known substances. Section 3D, as we have covered, deals with new forms of known substances. Okay, so somebody comes up with a new form of a known substance, then if it falls within the explanation, and there's an explanation to section 3D, you have to demonstrate that the new form is has more efficacy than the earlier form. Now, I'm telling this particularly with regard to pharmaceuticals. In pharmaceuticals, there is reduction of particle size itself is an innovation. But particle size reduction, which could be done by using nanotechnology, would come under the explanation, because particle size is regarded as a new form of a known substance, and the applicant will have to show that by reducing the particle size itself, they may not get a patent. They may have to additionally show how that leads to enhanced efficacy. Now, this could be a difficult thing in pharmacology, because just by reducing the particle size of the active ingredient, you may have to now show how therapeutic efficacy, or how that can lead to quicker healing or quicker treatment of diseases. So bear in mind that from a patenting perspective, there is no separate requirement for nanotechnology. It's just like any other law, but there could be an exception when it comes to pharmaceuticals, especially when you are talking about new forms of known substances, because the explanation in section 3D covers particle size. So if you use nanotechnology to reduce particle size of a known substance, that may itself not get you a patent unless you show that the new product now has enhanced efficacy. And if it's a medicine, then you'll have to show that the enhanced efficacy is actually therapeutic. Okay, we have already covered suggested books. There are freely available books which we have already shared on the forum. We can share it again. The WIPO has material, quite a lot of material on intellectual property rights, and we also have another UGC had this e-Pathshala, where material is available on intellectual property courses. So that's one of the reasons why we did not, because they're all standard courses, tried and tested. So we just given reference to them. And kindly explain the total term of copyright. Copyright is applicable to quotation and how to avail it. Okay, the term of the copyright, if the creator is an individual, an author, it runs from the year of creation. Actually, it starts with the life of the author. So if I create a work in 2018 and say I live for some more years, my term will be the life of, that is my life up until my death, plus 60 years. So the copyright term will be life of the author, regardless of when the author wrote his work. So till he dies, from his death, there is an additional 60 years. Now, all of Gandhiji's works came into the public domain somewhere around 2009. So that was life of Gandhiji plus 60 years, they came into the public domain. Now, this is the term of the copyright. If it's an individual author, regardless of when the author wrote, the author would have written different books. I'd written a book in 2007, one in 2016. So regardless of the term, they will all have a term which will expire at the same time, because it is tied to my lifespan. So when I die, After my death, the term will extend for 60 more years. Now, quotation, there is no hard and fast rule on how much you can quote. The law is quite flexible there. In some works, especially that emanate from United States, they may even say in the copyright page that you can only produce, if you have to reproduce or quote, this is all you can do. But quote in itself, it cannot, if you are quoting it for the purposes of research, say you are writing a scholarly article and you are quoting it, then there is a limit to which you will not quote, say, 10 pages, right? You will only quote what is required. So as long as you quote what is required and it does not look as though you are passing off somebody else's work by quoting them extensively, it will not amount to copyright violation. Copyright law protects quoting other works. It can You can quote provided you attribute the source and give a reference. So there is no limit as to how much you can quote. It largely depends on the work that you are doing. Say you are doing a work on a critical analysis of one of Shakespeare's plays. You may have to extensively quote Shakespeare because that's a critical analysis. So your entire thesis, PhD thesis, is, say, on that one play. So you're going to extensively quote it. Not that Shakespeare's works are protected anymore. I'm just giving you one instance. So if you are doing a critical analysis of somebody else's book, say you are writing a book review, then you may have to extensively quote it. So it depends on the case in which you are, what you are doing, or if you are doing a critical analysis or a PhD on somebody else's written work, which is still under copyright, you can use it because now you are into the research domain. So again, the purpose for which you put to use, whether it's commercial or non-commercial, whether it is research or education, all these things will govern the amount or the limit to which you can quote. So we don't have any more questions. If you have, please raise them on the forum. We will have one more session, that is next week. We will certainly try to cover the, the prior art search. I will bring one of my colleagues who has been working abroad and in India and who is an expert in search. So we will have a session. It will be a live session, and we will take it forward from there. In the meantime, we will have one more session next week where we can where I will tell you about case laws and the importance of case laws, and I will also be happy to answer questions in that session. So we will conclude this session for now. Thank you.